aspiring turnaround practitioners need to be well versed in the rights of creditors during a business rescue to ensure fair treatment and adherence to the rights of creditors. Whether you are the business rescue practitioner or representing a creditor, you must be aware of the intricacies of Chapter 6 of the Companies Act. Your host for the session is Pattinson, a professional turnaround practitioner with a success rate of more than 95% for all business rescue plans published to date. Pat specializes in the compliant and ethical rehabilitation of distressed businesses towards an outcome of saving businesses, saving jobs, and providing the best possible outcome to all affected persons.
Good morning, ladies and gentlemen. Welcome to this Friday session. Topic for today is the rights of creditors, obviously referring specifically to business rescue in terms of Chapter 6 of the South African Companies Act. Keeping in mind that business rescue is a creditor-driven process. Ultimately, the creditors vote on the proposed business rescue plan, and it is important for creditors to understand what they're voting on, what their process are, what their rights were throughout the process. The reason for that is that once a business rescue plan is adopted and voted in by creditors, that's binding on all affected parties, whether they knew about the business rescue, whether they took part in the process, whether they voted for or against the proposed business rescue plan. Once the plan is adopted, it's binding on all of the affected persons. And it's going to be very difficult to, after the fact, want to argue that you did not know, I did not know. That's simply defense. That's not going to work, and unfortunately one that I've come across so many times. So the purpose of this morning is to go through some of the most basic rights. These rights are often challenged in court, but equally so, and probably more importantly, and it's important for all, especially your junior practitioners out there, to keep your ear to the ground when it comes to new case laws and new judgments, because these new case laws and new judgments create new rights to creditors, or they could remove rights that we thought that we had. We'll discuss a little bit later on. There's no longer such a thing as an automatic nullity, although the Companies Act specifically alluded to that. But we'll get to that. Let's not jump the gun. I hope you enjoy the session this morning. So as I've very quickly mentioned, is the rights of creditors is an ever-changing environment. You have to keep looking at whatever case laws are being made, reported, unreported, and more important than even case laws, there are some unwritten rules, unwritten processes, expectations from creditors, especially your bigger lenders, your bankers. I've attended some of the SERIPA conferences, and when you read between the lines, although they are not necessarily written in stone or provided in court cases, there are certain rights, certain expectations, and certain mannerisms in which the creditors expect practitioners to act. But equally so, creditors must understand that a business rescue practitioner have also got certain rights and certain limitations. It's not equal to that of a liquidation where the company will no longer continue trading and all the intellectual property is available for everybody. No, a company still has a right to its intellectual property and its confidentiality. Business rescues also should not be a culture of bullies where you are being forced, where fallacies of perfection or everything else are being used to try and convince creditors to accept a narrative where different possibilities still exist. So communication is vitally important throughout the process. And there's where we get to Section 7K of the Companies Act that we'll chat a little bit later about. A practitioner must look after the best interests of all of the affected persons. And what often happens is you may have a specific creditor's perspective that is 100% correct, but you might have an opposing view from a different creditor, and his view is also 100% correct. The practitioner is then tasked with the unfair responsibility of choosing which way to go. And sometimes it happens that the practitioner chooses neither one of those, but have got his own direction. So the possibility for several options to exist is there. All of those options are right. And then care must be taken by the practitioner as to which of the options he challenges and which of the options he adopts. And that is where, again, the communication to creditors, communication from creditors, the negotiation between the parties are vitally important. However, equally important, there can't be an expectation for communication only from the practitioner's perspective. So the rights of creditors, as I've mentioned earlier, there are those tacit or inferred rights, not necessarily reduced to writing, to courts, anything else, but fair communication, in some instances, notices, that is required, which is not necessarily written in law, but it's an expectation. And those are often the most important ones when it comes to relationship building. The more direct rights of creditors are to be notified of the process, the right to take part in the process, the right to oppose the process, and then ultimately the right to vote on the proposed business rescue plan that the business rescue practitioner ultimately publishes. The question is then, but what happens if these rights are not adhered to? What happens if a creditor feels that the rights that he had in business rescue was not kept up and he was kept out of the loop? And this is where we jump back to what I said earlier. The creditors have an equal responsibility to take part in the process. There are certain creditors meetings that the practitioner have to hold. Attend those meetings, take part in the process, take part in the communication. If you don't get your answers, communicate with the practitioners, communicate with the rest of the creditors, form the committees. You have to take part of the process, vote on the process. If the outcomes is not what you desire, don't wait for court and run to court first. Try alternative dispute resolution and try and get to understand the views, because simply not being happy is not sufficient. You need to understand the reason behind the decision that was taken that you are not necessarily happy with. As I often say, there are cases where a creditor employs an attorney. The attorney looks after the rights of that particular creditor. But there are 2 or 3 other creditors who also have attorneys, and their attorneys also look after their specific creditors' rights. Unfortunately, the business rescue practitioner does not have the luxury of just looking after one person. He has to look after the group. It's a utilitaristic approach that he has to take to make sure that he provides the best outcome to all of the affected persons, even if that means that some of the persons are worse off than what they could have been if they acted on their own, or if there was no business rescue process. So the first right that I'd like to discuss is the business rescue process. There are 2 ways for a company to go into business rescue, and this is one of the most important rights of a creditor and one that's often misunderstood. A company going into business rescue should not be a punitive measure. It should not be a way to avoid paying creditors. In fact, creditors must insist that companies go into business rescue, voluntary business rescue in terms of Section 129. Alternatively, a creditor has the right to force a company into business rescue in terms of Section 131, where you would go to court to have a debtor put into business rescue. Business rescue remains a better outcome than that of liquidation if it is done early enough. So the right for a company to go into business rescue is almost less valuable than the right for a debtor to expect that company to go into business rescue. And then just a quick summary, if we look at Section 129(1) of the Companies Act, it says that any company that's in financial distress, the board of directors may elect to go into business rescue. A confusion section. Because 129(7) then says if the company did not go into business rescue, that board of directors must notify all of the affected persons by a formal notice that you get from the CIPC that they are in financial distress. Not doing these 2 things, if a company is in financial distress, could result of the board of directors being accused of a contravention of the Companies Act, which in turn have got a whole different set of ramifications to the board of directors. But that's not something we're going to discuss in this session. It's really a topic on its own. The second right is then to be informed. When a company goes into business rescue, there's responsibility, first of all, on the board of directors to notify the affected persons. When the practitioner is appointed, he then has an obligation to notify them. And he has to continue keeping the creditors informed throughout the process, not necessarily through creditors' meetings. There are some creditors' meetings that are forced. For myself, for the rescues that I take on with other practitioners, we hold at minimum 1 creditors' meeting every month to inform and update the creditors. We also don't ask for 6-7 month extensions. Our extensions are always from 1 month to the other. in order to provide the creditors with feedback and give them the opportunity as to where they stand in the process. Then naturally, if the creditors have a right to be part of the process, they have a right to oppose the process at any point in time by approaching the court to do so. Again, I remind you that the court is not the only option. If it is a matter where there is a dispute between what a specific creditor would like to see, a specific group of creditors would like to see, alternative dispute resolutions may be a faster and a cheaper option to go. And actually, in business rescue, we do not have the luxury of time. We have to act quickly, and these alternative manners will be the best option available if you can reach an amicable conclusion. The fourth right is, of course, to vote on the fee agreement of the practitioners, but do not be confused. Regulation 128 provides the hourly rates that the practitioner is allowed to charge. Those rates are dependent on the size of the company, not the level of qualification of the business rescue practitioner. So even a senior practitioner working in a small company will have to charge the fees of a small company. He's not permitted to charge the large company fees because he's a senior practitioner. I see it often in practice where those two are confused. And then where the vote comes in is in terms of Section 143 of the Companies Act. That is where practitioners request additional remuneration in the form of contingencies. Contingency being that if a certain event materializes and is concluded, is entitled to receive an additional fee. The example that the Companies Act provides is that an additional contingency could be charged on the adoption of a business rescue plan. We see it more often than not that the practitioners also ask certain commissions and fees to be paid on the sale of assets, movable and immovable, the business, parts of the business, and even on the raising of post-commencement finance. These are the votes that the creditors have, but of course you don't want to be unrealistic. Practitioners perform a very important deal. It is a difficult process, so pay the piper what he earned. Right to be consulted in the drafting of the business rescue plan. If we look at Section 150 that governs the information that goes into a business rescue plan, one of the very first paragraphs and writings in that section is to provide the creditors with all of the information that they could reasonably require to apply their minds on whether to vote for or against a proposed business rescue plan. But again, ladies and gentlemen, be reminded of the fallacy of perfection. A practitioner does not have to provide all of the information of the company. Certain information remains the intellectual property of that company, and it must be confidential. This is very different to the Insolvency Act, where all of the information is available. If the company is going to continue trading going forward, suppliers, customers, rates, locations, formulas, those remain the intellectual property of the company, and the practitioner would not want to share that with you. In fact, you could be held liable if you overshare certain information. So yes, creditors have a right for the information they reasonably require to apply their minds to vote on or against a proposed business rescue plan. Naturally, then also, as I've mentioned earlier, the business rescue practitioner must allow the creditors to form a committee. That committee will then negotiate amongst each other, and they will represent the creditors. They do not vote on behalf of the creditors. They do not make decisions on behalf of the creditors. In smaller companies, I have found that creditors committees becomes cumbersome and unnecessary, but in larger companies where there are a substantial amount of creditors, I do prefer working with the creditors committee. The creditors committee will come to the practitioner for all the comments and questions from the creditors. The practitioner will communicate to the committee, and the committee in turn goes back to the creditors. But ultimately, all creditors still permitted to attend all of the creditors meetings, receive all of the notifications, and they are each allowed to vote on their interest at the publication of the business rescue plan. The creditors committee do not vote on behalf of the entire body of creditors. There are very strict timelines in the Companies Act for business rescue. 5 days to notify the creditors, appoint a business rescue practitioners, the first creditors meeting in 10 days, publish a plan within 25 days, vote minimum 5 days, maximum 10 days. Very, very strict timelines. And in the Companies Act, it is written that if the practitioners do not stick to these timelines, it becomes the business rescue process, and the filing for business rescue becomes a nullity. Later in business rescue and in the judgments and in the case laws, as I've alluded to early on, it was the Panama property matters where it was concluded by the court that there can be no such thing as an automatic nullity. If any one of these timelines are not adhered to, it will simply provide the creditors with the right to approach the court to have the business rescue process set aside. In my view, I don't understand it because creditors do not need a default and timeline to approach the court. It could be a motivating factor, but at any stage, a creditor could apply to court to have the business rescue process and the resolution set aside. Section 150 is, of course, as I've alluded to before, the details that must go into a business rescue plan. It is set out very clearly in the Companies Act. Some amendments have been made, but to a large extent, what has to go into a proposed business rescue plan is contained in Section 150, and the creditors then naturally have a right to that information, keeping in mind the intellectual property of the business. Once a business rescue plan is then published, when it comes to a vote and the plan is perhaps not voted in, or before the vote, the creditors have a right to ask for amendments to the proposed business rescue plan. Some amendments can be included during the vote. In other instances, the business rescue practitioner would have to ask for a postponement of the vote, scheduled for a later stage, and then to include those amendments into the business rescue plan and then present it to the creditors to vote on again. Fallacy or false dilemma is where a practitioner will state, this is the only option to the business rescue plan. If we do not accept this business rescue plan, the company will be liquidated. A complete side note, the failure to adopt a business rescue plan does not allow a practitioner to liquidate a company. The only time a practitioner is allowed to liquidate a company is at some point where he believes they are no longer a reasonable prospect of rescue. If the practitioner believes in his plan and the plan is rejected, he is obliged to hand the company back to the shareholders and the directors, not to liquidate the company. As I've mentioned earlier, there are some reported judgments that is very well known in the industry, but there are some unreported matters. On this particular point, there is a Delport versus McLaren matter in the Eastern Cape, where it was concluded that a business rescue practitioner does not have the right to enter a company into liquidation after the vote has failed or after he has filed for substantial implementation. The 10th right is that a creditor must be allowed to facilitate and assist and be guided with the implementation of the business rescue plan, even after it was voted in. The business rescue plan is a binding contract on all parties, again, whether you knew about it or not. Should there be a default in the implementation of that business rescue plan, there can be a problem. And this starts in Section 152, where the creditors vote on the plan, where they can ask for amendments, extensions, etc., etc. If the plan is then rejected, creditors have several other rights in Section 153, making binding offers on the debt of those creditors who voted against the plan, asking for amendments, asking for a new plan. It remains the creditor's duty, obligation, and right to determine what happens if a plan was rejected. In some instances, even where the plan was adopted, if creditors believe that that was not right, they can apply the court to have that vote set aside on the grounds that it was biased, unjust, unfair, where the creditors feel that the business rescue practitioner perhaps looked after one specific creditor rather than the entire body of creditors. A very difficult thing to prove, but if you take a holistic belief, if you take a holistic view and you believe that that was the actions, you have a right to approach the court in that instance as well, which is, of course, right 11, where you have a right to oppose the business rescue plan. Whether it was adopted, whether it was rejected, creditors do have a right to approach the court to have that vote set aside. A personal request from my side, if you consider opposing a positive vote on a plan and you want to go to court to have that positive vote set aside, it's just the honorable and ethical thing to let the business rescue practitioner know of your intentions. You don't need to have the court papers ready, but ladies and gentlemen, it is extremely difficult to unscramble an omelette once it has been cooked. If the business rescue plan is adopted, especially on an urgent matter, and the business rescue practitioners start implementing the steps as per the business rescue plan, and then weeks later they find out that there is an application to have the vote set aside, everything that they've done in between, they've done in good faith, and it becomes very difficult to reverse that should the court then eventually decide that the business rescue vote was unjust, and it just makes things very, very cumbersome and difficult. Then, of course, your 12th right, our second last one, is to receive the dividends as per the adopted business rescue plan. If you do not receive it in the terms of the plan, again, you can go to court to have the plan set aside. Once the plan is set aside, of course, all of the conditions and the provisions in that business rescue plan becomes a nullity. Creditors have a right to approach the company, go after their full debt without any compromises, without any payment plans. So just because a plan is voted in, your rights doesn't end there. Your rights end when you have been paid in terms of that adopted business rescue plan. On the other side of that coin, please be remembered, you are only entitled to receive the dividends as per the business rescue plan. And if the business rescue plan prevents you from going after sureties, you can't even do that. But the business rescue plan must be clear that you cannot approach or cannot pursue the sureties. In the absence of that, sureties are not automatically protected in a business rescue process. Then another inferred right, not necessarily set out in the Companies Act, but you have got the right, and in my mind, obligation to seek expert advice. Go and see accountants, go and see attorneys that know business rescue. Please remember that the attorney that did your divorce is maybe not the right one to assist you in a business rescue process. It's a tricky environment. It's a difficult thing. It's not the ordinary course of business. Ladies and gentlemen, then on that note, I'd like to thank you very much for spending your time with us this morning, and a big thank you to our sponsor as well. Let me quickly hand over to Mr. David Masterton.
Hi, I'm David Masterton, Director of BR360. BR360 is a company that specializes in business rescue. That is why we wanted to team up with Pat and sponsor these episodes. These episodes provide insights not often spoken about. We look forward to future episodes and engaging with you, the viewer. Hope you enjoy Pat's insights and find it useful. Please feel free to contact us.
The views expressed in these episodes are solely those of the presenters and are based on their personal experiences. They do not necessarily represent the views or opinions of any professional associations or organizations with which the presenters may be affiliated. The content of these episodes is for informational purposes only and does not constitute legal, accounting, or any other professional advice. Viewers are encouraged to seek advice from qualified professionals regarding their specific circumstances.
Thank you for watching with us. If you enjoyed today's episode, please remember to like, subscribe, and follow us for more. Thank you.